Good evening, and welcome to tonight's Zoning Board of Appeals meeting. Let me introduce some members of town government that assist this board. To my left is Simone Bogany, Assistant Town Attorney. To her left is Blaise Donadio, a planner in the Planning Department. You're all here tonight seeking relief from the Smithtown zoning ordinances, and it's our job to try to help you achieve the relief you are requesting whenever possible. It's up to you to provide this board with precise and accurate information so we can make a decision based on the facts presented. This board must consider the 5 area variance considerations in order to render a decision, and they are as follows. They're also listed over here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created by the granting of the variance. Number 2, whether the benefit sought by the applicant can be achieved by some method feasible for the applicant to pursue other than the variance. Number 3, whether the requested area variance is substantial. Number 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district. And number 5, whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the board but shall not necessarily preclude the granting of the variance. Procedures for tonight's meeting. Cases will be called in the order they are advertised. When you are called, please present your certificates of postings and mailings to Mr. Donadio. Then you will be asked to go to the podium. We will state your name and address for the record and proceed to tell us why you need your variance. At the end of your presentation, if anyone in the audience would like to speak on your case, they will be given one opportunity to do so. Then the applicant can come back to the podium to answer their concerns. Once the public hearing is closed, no further information will be accepted concerning the case. There are 3 ways to find out about your case. You can stay after the hearing, but there's no guarantee your case will be acted on tonight. You can call the planning office tomorrow at 12 p.m., or you can wait and be notified by mail. We do have one adjournment, and that is case number 18725, Bassett Kaufman of Smithtown, LLC. That has been adjourned to August 9th. Anybody here for that case? Okay.
Thank you, Mr. Chairman. The first case on the agenda, case number 18749, Michael Bracolo, 6 Lewis Place, Nesconset. The location of the property is the southwest corner of Lewis Place and Commander Lane. The property is zoned R10. The applicant is requesting variances to reduce the minimum front yard setback from 40 feet to 15 feet on Commander Lane for a proposed 916 square foot gazebo. To reduce the minimum front yard setback from 40 feet to 9 feet on Commander Lane for a proposed natural gas-fired generator.
Good evening.
Good evening. I have photos to submit.
I'll take them. Okay, thank you.
Appearance Zachary Foreman from the Law Office of John B. Zolo, PC, 12 Manor Road, Smithtown. For the record, the applicant has already filed their affidavit of posting and mailing with the board. We're here for the applicant, Mr. Michael Bracolo, property 6 Lewis Place, Nesconset, Suffolk County Tax Map Number 141-4-51. As the board previously stated, we're requesting area variances, reducing minimal front yard setback from 40 feet to 15 feet on Commander Lane for a proposed 196 square foot gazebo, and to reduce the minimum setback from 40 feet to 9 feet on Commander Lane for a proposed natural gas-fired generator, As the board mentioned, Mr. Bracolo's property is located at the corner of Lewis Place and Commander Lane. If you saw the picture submitted to the board, as well as the overhead map photograph, Mr. Bracolo already has a fence securing his yard, and both the application for the gazebo and the generator would be located behind that fence. If you see those pictures that are submitted on the screen, that is the proposed location for both items. The basis for Mr. Bricolo's application is twofold. There's no denying that the gazebo and generator could serve a personal and social value and benefit. However, this application is being made on a medical necessity basis as well. Mr. Bricolo was still is a firefighter through and during 9/11, in which he came down with ailments that requires refrigerated medication, as well as severe sleep apnea that requires to be treated with a CPAP machine. He's previously treated for melanoma twice and had it removed, and now, in order to be outside, the doctors are requiring Mr. Bricolo to utilize proper and adequate shading. The subject application accounting for the generator would be used in the event of a power outage, which would allow Mr. Bricolo to power not only his refrigerator to refrigerate his medication, but also to have his sleep apnea machine, the CPAP, operate properly in the event of a power outage. The gazebo being applied for 14 by 14, as you can see on the screen here, that's to provide adequate shading and sufficient space in the backyard. If you see the photos submitted, the backyard doesn't have any natural shading, no trees, no other awnings, nothing like that. So this would be the sole shading provided in the backyard. Along with the medical necessities that I stated, I do believe that this application, both items, will satisfy the 5 prongs of the 267B test. First, there is no undesirable change. The PVC material of the proposed gazebo would match with the already existing fence and be located behind the fence line. The other houses in the neighborhood have other similar backyard structures. This would not be an eyesore or anything like that. As laid out before, the benefit and relief sought, it really can't be obtained in any other way. The house does not have any natural shading already. The gazebo would provide that level of shading for Mr. Bricolo to utilize his backyard. The generator, in fact, itself is a self-fulfilling prophecy. In the event of a power outage, he'll need to power his refrigerator to have medicine and need to have a CPAP machine to get proper sleep and stay alive. Number 3, we don't believe this is a substantial request. As I previously mentioned, both items will be located behind the fence line, and they won't be impeding on any neighboring properties or anything like that. Number 4, the application will not have a substantial physical or environmental impact. I would argue that the gazebo would have no impact, and the generator would be minimal at the absolute worst because its intention is only to be utilized in the event of a power outage. And number 5, I believe it goes without saying, but this difficulty was not self-created. Mr. Bricolo did not bring upon these medical conditions on his own. And thank you.
Thank you. Does anyone on the board have any questions on this application?
No,
Planning?
No questions. I just have one comment to make to the board and council. It does say in the call of the advertisement that the proposed gazebo is 916 square feet, and I believe that the proper dimensions are 14 feet by 14 feet,
Yes.
which means that the actual gazebo would be 196 square feet. So I just want everybody to be aware of the fact that I believe there's a typo in the advertisement.
Yes, Board. I believe I said that in my opening
Okay.
appearance, but I just wanted to make sure. Thank you.
Thank you.
Thank you. Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried. Thank you.
Thank you.
The next case on the agenda is case number 18750, Tipu Shiketh, 115 Caramel Road, Comac. The location of the property is the east side of Caramel Road, 762 feet south of Caramel Court. The property is zoned R43. The applicant is requesting a variance to reduce the minimum front yard setback from 60 feet to 54 feet for a proposed 322-square-foot roof-over porch.
Good evening, everybody.
Good evening.
My name is Tipu Sheikh, and I'm a resident of 115 Caramel Road, Comac, New York, 11725.
Okay.
And I think it's very short, adding another 322 square foot to my front, extending another porch so it will reduce the setback from 60 to 54.
This is just going to go right over your porch,
Yes, sir.
give you some protection in the winter from the rain, snow, and...
Absolutely, absolutely.
Okay. Anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Anyone in the audience like to be heard on this application? Have a motion to close the application, please.
So moved.
Second.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Thank you, sir.
Thank you very much.
The next case on the agenda is case number 18752, Michael Davis, 10 Highwood Court, St. James. The location of the property, the south side of Highwoods Court, 245 feet west of Highwoods Road. The property is zoned R43CL. The applicant is requesting variances to reduce the required setback of a 5-foot fence on top of a 4-foot retaining wall from 4 feet to 0, to increase the maximum height of a fence on top of a retaining wall from 6 feet to 9 feet, to reduce the setback of 4 existing retaining walls from a lot line from 6 feet to 0 on the west side, to permit environmentally sensitive land, slopes in excess of 15%, to be altered for an existing 539-square-foot roof over cabana, to reduce the minimum rear yard setback from 75 feet to 70 feet for an existing elevated rear deck, to increase the maximum permitted paved surface in the front yard from 25% to 51% for existing paving.
Good evening.
Good evening.
Are you the applicant, sir?
Yes, I am.
Okay, could you state your name and address for the record, please?
Michael Davis, 10 Highwoods Court, St. James.
Would you like this gentleman to speak on your behalf?
Yes, I would.
Okay, fine, thank you.
Good evening, Mr. Chairman, members of the board. For the record, my name is Michael Morbillo, architect. My firm is Anspire Design Group with offices located at 273 Lake Avenue, St. James, New York. The application before you tonight is primarily for a fence on top of a retaining wall and some lot coverage. I'm going to run through, as there's several items on the agenda that I'd like to just go through and outline. The first few items actually are related to retaining walls, which are on the south and west side of the property. And we have some pictures that are shown on the screen. And primarily, what's characteristic in this area being up against a green belt, the Smithtown green belt, if you're familiar with the neighborhood. There's a severe slope drop-off on the back of many of the properties in the neighborhood. And my client probably about 12 years ago, constructed and did improvements on the property after there was a fire. There was a fire on the property originally about 12 years ago. His home had basically burned down, and he rebuilt the home. At that time, he did other yard work. He had some issues over time with, immediately after filing the permits 12 years ago, with insurance and other things, and it delayed, moving forward and finalizing a lot of these structures, which have now been around for well over a decade. He is now in contract to sell his home, and we're looking to legalize all these structures that are on there. But primarily, they built a new home, and to create a backyard, a level area in the backyard, they constructed retaining walls on the south and west side. There's also their neighbor to the east is a little bit higher, so there's a retaining wall on the east side. What you can see here is primarily we have something where we have a estate-type fence on top of these retaining walls. The walls basically face the greenway, so they really have little impact on any surrounding properties. They're barely noticeable. There's a lot of lush landscaping and other things around these walls. There's also an estate fence, which you can see is somewhat, in the lower picture, is somewhat transparent, and it doesn't have a substantial impact. On the west side of the property, the retaining wall, which faces the neighbors, is actually facing like an undeveloped area in the neighbor's backyard where there's sort of severe drop-offs. So that's a west retaining wall. That's actually alongside the neighbor's house, and there may be another one along there, but primarily, there's another one that this is the neighbor's property, and we have this sort of severe drop-off, and then this estate fence on top of the retaining wall. And to the west of this is I have some pictures. You can see is a largely wooded area. We think primarily very low impact on anybody. So we don't look at these structures as having a substantial impact. Certainly, they've been in existence for 12 years. They haven't had an impact on the environment, and a lot of landscape and other things have kind of grown up around them over time. Some of the other requests we have is certainly standard. When we have a higher slope area, it's designated as environmentally sensitive lands. We're always in front of this board many times when we have retaining walls. And also, there's a cabana you could see in the lower picture, which is towards the southern boundary of the property, which is within 10 feet of what formerly was a steep slope area. So that's also on the agenda. But again, the structure's been there for a dozen years and has not had an impact on the environment or on the quality of the neighborhood. It's barely visible, and certainly not visible from the street. The final items on the request have to do with reducing a rear yard setback for an elevated deck. So we can see that in the upper picture. There's an elevated deck, again, been there about a dozen years. There's a walkout basement underneath the deck, which is common in hilly and sloped areas. And that deck is supposed to be 75 feet, and it's 70 feet from a rear yard. It's about almost 7% encroachment. Again, not a substantial impact or a substantial request. The last item on the request is for increasing the maximum permitted paved surface. So that has to do with the driveway. And certainly on this is a common request I've seen before, where we have a circular driveway and we exceed the minimum 12-foot requirement. So in our case, we're about 16 feet on average, and then we widen up to where the garage area is. But if I did an analysis of the circular driveway, and the first 12 feet of it represents about 31% of the 51%, because now all of it, as you're aware, all of that driveway is now included in the request. You know, when you go from a 12 foot to a 13 feet, well, you don't have that exempt from the lot coverage. So we now have 51% of the required front yard is now covered in paving, but if it was a 12-foot wide driveway, that's excluded. So that 12-foot portion, like if I were to just say, oh, it was a 12-foot, we'd actually only be at 20% of FAR, because that 12-foot portion is exempt. And so it's something that we see when we have a circular driveway that exceeds that minimum 12-foot width. As I've gone through, you know, there were circumstances, whether things are self-created, in other words, you know, you had a fire, redeveloped the property, it got dragged on due to insurance issues and other financial issues, and so we don't feel that this was self-created. There wasn't really, we're on a slow property, we run into these types of scenarios in slow properties. So if the board has any questions this time, I'd be more than happy to answer or clarify.
All right, thank you. Does anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Simone?
There are open violations, from my understanding, with this property.
Yes, that's related to expired permits. So those are the violations that, you know, the permits, he initially took out a permit 12 years ago. You know, so those permits have been opened, you know, have been renewed, and they're expired. He has renewed those permits, but then the violations aren't going to be cleared until we obtain, you know, certificates of compliance, and that's obviously why we're in front of this board. Part of it is that there's an open violation, and we have to rectify all this. And permits were issued, but they haven't been closed out. So there's a cabana permit, there's an in-ground pool permit, retaining wall permits, a new dwelling permit. So all of those things were, permits were filed on them, just never closed out. So that's where the violations are. My clients had to go to, I believe, had to go to court to, you know, let them know that they're working on it. I may be mistaken, but I'm pretty sure he's had to been there to make them aware of that.
And the reason they weren't closed out was because
The reason-
financial reasons with the
It was
insurance company?
financial reasons, yeah. You know, he didn't get any insurance. So, you know, he's allowed me to say that he had to go bankrupt because he didn't get insurance to cover the damage, or it wasn't enough or whatever to cover the damage. There was issues. And that put him in a very bad place for many, many years. And finally, he was able to get on his feet even after work was done, and was able to get this, you know, get this reinitiated. So it was due to financial reasons, he wasn't able to close these things out. Also, at the time, they did make them aware, like, you know, you need variances for some of these things. So there was a denial that was actually issued originally, I think, about 10 years ago. So, you know, there was awareness of it. He didn't have the means to be able to close everything out and do it.
All right.
So,
Okay, thank you.
okay.
Is there anyone in the audience like to be heard on this application? Sir?
Good evening. My
Good
name is Thomas. The cane is not in case you make the wrong decision.
Okay. Thank you.
So far, so good.
Okay. Could you state your name, spell your last name so we get it correct on the record,
Gotcha.
and give your address, please?
Okay. Thomas J. Spellman, S is in Sam, P is in Peter, ELLMAN, Jr. I and my wife, Margaret, who's seated here, are the owners of 8 High Woods Court, St. James, New York, 11780. That's the land that is immediately to the west of the applicant's property. We've lived there 49 years. It's a great neighborhood. It's unique, as you have been advised. It's right in the middle of the, we'll call it a green belt. The Nature Conservancy and the town own the property all around it. So there are 35 homes in this neighborhood. There is, and this is what makes it rather unique, each home backs on this Nature Conservancy 100-acre property. Nobody has any backside neighbors, backyard neighbors. And so that's one thing. The homes are all well-maintained. There's no, it's, again, as I say, the thing that makes it unique is you come into this neighborhood on High Woods Road, which is a steep road. At the top of High Woods is High Woods Court. You make a left or a right. Whichever way you go, down to the end, there's a cul-de-sac. So we have two cul-de-sacs. And you can go around and around, but to get out, you can have to go back to High Woods Road. So it's kind of self-contained. Again, a unique situation. The homes were built in the area of 1968 or so by, for the most part, by different builders. Some of the homes were built by the same builder, 2 or 3, but it's generally, you know, they're unique. Different construction, different design and whatnot. Now, having said that, I was prepared to go into a lot of questions that came up here, but in hearing this and in reviewing the file that I reviewed at the planning board office, I'm somewhat confused. There is something from a memorandum from the building department. If I can find it, and I can. It's to the Board of Zoning Appeals from William W. White, Smithtown Building Director. Reference denial of building permit, residential, principal, and accessory structures. It's with reference to this. Okay. My voice is going. My dear wife has a bottle, it's only water. If I could, thank you. It looks like it isn't water, but it's water.
It's open.
Thank you, dear.
You need it.
All right. Excuse me.
Want me to stay up here?
That's okay. The memorandum from William White lists a number of things. Excuse me. But on the second page of it, and it's in your file, it's the denial of the application, of the building permits. Towards the end of it, it has comments. Variance based on info on survey submitted on June 10th, 2010. That's important. We're now in 2022. And also it says, per survey submitted, dash, 2 retaining walls extend over property lines to adjoining property to the west. That's ours. In effect, it says it's encroaching over the property line. Survey used, dash, lists last update as January 28th, 2010. All right, again, we're in 22. Then it says, for fence on top of retaining wall, The heights used were provided by the applicant. My problem is, I have not seen a current survey. And the survey, there are two things in the file, maybe more than two, but one is a plot plan, and for the Davis residence. And this is dated May 27th, 2022. And this is from Inspire Design Group, Mr. Morabito's outfit. It says, the information taken from a survey prepared by Elizabeth McQuicklin, Lisa McQuicklin, Land Survey. Doesn't say when it was taken. There's no indication, okay? Now, there is a survey all of this comes from the BZA file, or the Planning Department file. And this survey is dated, the last date on it is November 3rd, 2008. That's the last update. I'll be darned if I can tell you exactly where this retaining wall is or isn't. And so my request to this honorable board at this time, without going further, because of the concern of the encroachment, and quite frankly, with reference to this survey, that we don't have a up-to-date survey, would be that we adjourn this meeting, or this hearing, and that we get it straightened out, that the applicant present a current survey that shows whatever is there, where these lines are, and whatnot. Because if you look at the survey that's last dated November 3rd, 2008, and you look at the plot plan, they don't necessarily jive. And quite frankly, they're hard to read, in that, for instance, on the plot plan, the lines are so thick you don't know exactly what is where, and whether or not it, jives with any survey. So I'm asking for the adjournment in order to, excuse me, have the applicant submit a current survey that is legible and can be read and will indicate if there is an encroachment on my property. Because if there is, as I understand it, sir, I don't think that the BZA can do anything.
Okay. Let me just clarify one thing,
Yes, sir.
What I'm looking at,
Good?
it looks like there's a retaining wall on your property, but there's also a note, neighboring retaining wall. Mr. Morbillo is stating it's your retaining wall. I'm going to bring him back.
Yeah, I
To
understand.
clarify everything.
I understand.
But that's what is that
Now-
your main concern, the encroachment onto your property, sir?
Yes,
Okay.
because I don't understand it. You
Okay.
see, I understand, there is a retaining wall. We have a retaining wall that I'll tell you and it shows on the plot, it shows on each of them. And we could call it perpendicular in effect to
Right.
there.
Is that your retaining wall?
Yeah.
Oh, okay.
Yeah, but there's no indication, that's what I mean. I don't know what they're talking about when they say the retaining wall is encroaching on our property. I'm thinking if they're talking about the Davis retaining wall encroaching on my property, that makes it for a real problem.
Do we
And that's
have-
why
I'm
I
sorry,
want,
can I-
yes, sir.
Do we have that 2008 survey in the file?
You have, I'm sure you have this, because that's where I got it. I mean, I got it in the, okay. Got it.
Do you have it? Yeah. No, no. Mr. Mo-
I think Ms. Morbello may have it.
Mr. Mobilla has it. Yeah. Okay. Okay. Come here. Yes. The same one.
The latest update is 2000.
Same one. Anything else, sir?
Well, no, sir. To the extent that I am asking for an adjournment, excuse me, and for an up-to-date, a current survey, if you could answer that question, either in the positive or negative, you know,
Okay.
grant the adjournment or not, if you could answer that question now, and if it is that this would be adjourned, then I'll sit down and be quiet. If not, if we're going to continue on, I have comments to make with reference to the applicant's presentation. Am I putting you in a,
Yeah. We give everybody one opportunity.
yeah,
So if you have a lot to say,
yeah,
say it now.
okay,
Because if there's other people in the audience, we're going to bring them up.
yeah,
Once they're all done,
yeah,
everybody's had their say,
yeah,
I'll bring Mr. Morbillo back to answer your concerns, and then the case will be closed. So if you have other things,
okay.
addition to the survey,
I understand.
please let us know now, sir.
Okay, we'll go forward. You know, in other words, as of now, we are not adjourning the meeting.
No, as of now, no.
Gotcha. If you give me too much help, I'll be in trouble. The main reason that we came here this evening was, first of all, to make comments, which I kind of did in the beginning with reference to the uniqueness of the neighborhood and whatnot. Another reason would be to support any of our neighbors that may have particular or specific observation or objection to any of these multiple variance requests. I mean, there's 5 or 7, requests for a variance on different things. I don't think that should be ignored. And lastly, it would be from my point of view, to specifically oppose the variance request with reference to the west boundary, obviously, which is, my concern since it's on my next to my property. The file contains an application to the Board of Zoning Appeals. It's on printed form. On the second page, that's a May 2020 form from the town. On the second page is paragraph number 8. Area variance considerations. All questions must be answered. One, this is and it was, these are answers and signed by Michael Davis. One, the variance would not produce an impact on adjacent properties or the neighborhood because Mr. Davis circled would not produce an impact, and then he said, where it says because, he tells us it is consistent with adjacent development. Well, we disagree with that vehemently. A 0-foot setback is not consistent with the neighborhood. Nobody has the neighbor with a 0 side yard setback putting up a retaining wall or a fence. Second, the request is not substantial because Mr. Davis says it does not substantially impact the adjacent neighbors. Well, with this latest information about the encroachment on our property, the size of this wall, and the fence on top, I don't know how anybody could say that does not substantially impact the adjacent neighbors. Being the adjacent neighbors, yes, it does. 3, the benefit cannot be achieved by an alternative because Mr. Davis says it is an existing built prior structure. Mr. Davis built it. We know that. I mean, he makes it clear. We have something that in 2007, he was getting quotes and getting information with reference to the wall. So that seems to be a stretch. Number 4, the variance would not cause an adverse effect on the environment because he says it is consistent with adjacent development. I'm not an environmental, expert by any means, and I see that there is a report in the file from the Smithtown Environmental Department saying that they're not, it's not a problem, so we don't go into that. 5, the difficulty was not caused by the applicant or former owner because, Mr. Davis says, it was built without a permit. That doesn't answer the question. That's nonsense. He built it. He built it without a permit, so we know that. That does not answer the question. The difficulty was not created by the applicant. Yes, it was. Now, getting to the pictures, one of our major concerns is that strip of land from the front of the house on the west side of their house, going south towards the pool area and whatnot. There is a lot that I could overlook and say it's not what's the big deal? But in this situation, Mr. Davis continued the asphalt without the permit and whatnot down the west side of his house, which is again on our side with a 0 setback. That's pushing it a little bit. And that's the least of it, I think, the least of his problems, because he's not too concerned about it. He has ample room to park. He has a vehicle that he uses. I call it a pickup truck with some enclosure on the back. Fine. It shows in the 2 pictures, which are on 4 of 4 of his submission, the colored photos of the driveway. They're not, the pickup truck is not on that paved area I'm speaking of on the west side of his house, that there is no reason that he needs that to be paved with asphalt. Clearly, even the way he shows it, the truck park is parked in the driveway off to the right, plenty of rooms to anybody get around. So we vehemently oppose that part of his request, if it's included in the request. I'm not even sure it's included, and Mr. Morabito can tell us whether it is or it isn't. Also, with reference to the wall contains one or two, lately I haven't been getting around too well, so I can't remember, clearly one pipe that comes through the wall on the boundary line, if the wall is only on the boundary line, not over it, if it's on the boundary line, comes through the wall and would discharge, I have honestly never seen water come through it, but would discharge water onto our property. That's basic, law. You can't direct water, storm water, any kind of water, from one property to another. Direct it. If it flows naturally somehow, that's another story, but that's not the case if you direct it. So we have, a problem with that, or an objection. Let me see. Hold on, I think we're getting there. Accompanying me this evening, aside from the co-owner, my dear wife, is an attorney, Harvey.
Excuse me, can you just use the microphone, please?
Oh, I'm sorry.
Thank
yeah.
you.
I'd never make it. Anyway, is an attorney, Harvey Bisunder. And Harvey may have some comments to pick up after me in forwarding our opposition. With that, sir, I have finished my presentation, and I appreciate the time the board has taken and the patience to listen to it. I won't step on you. Thank you.
Thank you. Is there anyone else who would like to be heard on this application?
Hi.
Good evening.
Good evening. My name's Harvey Bisunder. I'm counsel to the Spellmans. If it's okay for me to speak, I'll be very, very brief.
Yeah.
I
Could you
just
s-
want,
What, can you just spell your last names? We get it correct for the record, please.
yes, I'm sorry.
And
It's-
your address, that's all.
It's Harvey Bisunder, B as in boy, Esunder. My firm is Margolin Bisunder, 3750 Express Drive South, Islandia, New York.
Thank you.
And I've had the opportunity to know Mr. Spellman and Mrs. Spellman for many, many years. And I just want to address a couple of things that Mr. Spellman said. And I think that looking at the criteria for variances, these applications are certainly substantial, especially with respect to the lot coverage issue. And again, to reiterate what Mr. Spellman said, it's not very clear whether or not the additional asphalting to the on the west side of the property is actually included in the 51% calculation. But that area goes to the west of the garage. The garage is a front access garage. The portion on the west side is not required to gain access into the garage, so that it is just an offshoot or continuation of the circular driveway that goes along the west boundary, and it's really not clear from the documents which are in the file as to where that is. And that, I think that's got to be addressed by the applicant, and I don't think it has been. So, running down the other criteria, the benefits sought with respect to that issue, that can be achieved by elimination of that additional asphalt, and the applicant will still have his circular driveway and all of the indicia of benefit that he will require without the necessity of that additional asphalt area. So that's one thing that could be taken care of. And with respect to the retaining wall, as Mr. Spellman said, in the event that there is an encroachment, and according to the documentation within the planning board file, there is an encroachment. It's really not clear where that encroachment is. And I understand your point with respect to the Spellman's own retaining wall, which runs perpendicular. It doesn't appear, and there's no indication that that is what was cited as the encroachment. And if in fact, as Mr. Spellman said, if in fact there is an encroachment onto their property and they are not supportive of the application, they're not party to the application, then there would be a jurisdictional question with respect to the BZA. And clearly, while the issue of self-inflicted hardship in and of itself might not be sufficient to deny it, where the self-inflicted, where the improvements have already been made, that makes the self-inflicted hardship a little bit more problematic for the owner. All of these improvements, or I should say construction, that were done without permits prior to the time that they made this application, probably 10 years ago. And clearly, these are self-inflicted hardships. That should be considered by the board as well. So I think I have addressed all of them. The major concerns, twofold. The encroachment with respect to the retaining wall, the height of the fence, which will clearly affect the quality of views and air flow to the Spellman's property, as well as the additional asphalt, which was not addressed. And other than that, I'll reiterate everything that Mr. Spellman said. Thank you for your time.
Thank you very much. Anyone else? Okay. Again, state your name, spell your last name.
Good evening. Hi, Francine Cotoya, Cotoia. I'm on the east side. The Spellmans are on the west side. My parents have been living in the neighborhood, and myself, for over, since 1970. So I'm really kind of surprised that the meeting is occurring now and not, 12 or 20 years ago when Mr. Davis moved in. Then we would have had the opportunity as neighbors to say, gee, I only put a small roundabout in front of my property, but there's a 50% difference in front of, and I would like to have a larger circular driveway. So I think it's interesting that variances are being asked for, requested now, not 20 years ago. There's little we could do. Can we say you have to rip up your driveway? And it's not consistent at all with the house that's directly across. In addition to that, he had a 21 square foot house that did burn and almost burned my parents' home. And he doubled the size to about 4,000 square feet. I'm not sure of a financial hardship. But what I'm really concerned about is putting up things that are not supposed to be put up, like a 10-foot fence. We would all like to have a 10-foot fence to avoid deer eating our, bushes, our expensive bushes in the back. But this was already done. Rules are good to have because when you live in a wooded area, like Mr. Spellman doesn't expect to have a big truck pulling in at 12 o'clock in the evening next to his house. Variances, rules setbacks are put into place for a reason, and people should be following rules with the town. I know my father did when he put up the the sunroom at the Elks. He did everything by the book. And I'm shocked. I'm an educator, so I'm listening to what was already done, and I'm thinking to myself, that's not the way it's supposed to be. When you're building a 4,000 square foot house, you should say to the neighborhood, this is what I want to do, but it's already been done. There is an impact when deer are running over a 4-foot fence. I'm a science teacher. And they can't get out the 10-foot fence in the back. There have been instances where deer actually drown in a pool. So I really take that to heart because there is an impact. Now, we could have put up a 10-foot fence. My mother had a tree that came down on her fence, but we didn't put up a 10-foot fence to keep the deer out. We put up a 4-foot fence, which is what we were supposed to do. All the neighbors have small fences. There's not one neighbor in the neighborhood, I know, I've lived there a long time, that have 10-foot fences or retaining walls more than 30 inches. Then it looks like a prison, trying to surround yourself like a castle. The house is the largest in the neighborhood. It's not consistent with the colonials. There's really not much consistent there. And I take pride in the neighborhood. We should, as town people, in that we follow the rules and procedures. So I guess I'm a little taken aback by even the fact that there is this meeting happening. And the neighbor across the street and I spoke. She would have loved to put in a 51% larger driveway for her children to come and go both ways and have double the traffic. But she didn't do that. She followed the rules. So I just want to say that it does make a difference to how you are living as a person. I think rules are put into place for a reason. I think variances should be sought before it's done, before the work is done. And I think it's a good practice for the safety of, the beautification of the town, the consistency of the neighborhood, for one thing. And why should he see a big truck pulling up? Why should the Spellmans see that? I wouldn't want that on the side. Then you have to put more bushes to block the truck pulling in. He's got plenty of area. Now, are you going to ask him to rip up his driveway now? Are you going to ask him to take the fence down? It's only a matter of time before a deer gets stuck in the pool or gets stuck on a cover in the winter. We follow the rules, and I think people should follow rules. They're not made to be broken. I'm not sure about a hardship. The house is 4 times anybody's size house there. So is the driveway. So is the boat. So are other things. Do the Spellmans have to look at a boat on their right-hand side? Should they have a 10-foot fence and a retaining wall on their property? I think we all need to investigate what really went on 12 years ago. And frankly, I'm disappointed with my neighbor, my parents' neighbor, and my neighbor. So I hope you take it seriously that these things are looked into, because I think variances should be done prior to building the object. Correct? Isn't that right? Isn't that the normal process? Yes?
I'm sorry, what?
Isn't that the normal procedure? You ask for permission, then you build.
Normally, yes.
Okay. So none of the neighbors had an opportunity to say yes or no to any of these things. We weren't given that opportunity. That's why we're opposing some of these things at this point.
Okay,
Okay, and that's it. Thank you.
thank you. Anyone else? Anyone else? Okay, that's it. Mr. Movello, would you like to come back and answer some of their concerns? Let's start with the driveway.
Okay. So we'll start with the driveway on the side, because that seems to be
Yeah,
a topic of much discussion by Mr. Spellman and Mr. Basunder and Ms. Katoya. I'm sorry if I didn't pronounce that properly. But as far as I'm aware, that's not on the request. They're allowed to have, that's not part of the front yard pavement. It's side yard pavement, doesn't exceed the requirements, so that is a completely irrelevant issue, but I'll have Blaze possibly, address that if he could while I'm speaking. If my assessment is correct, it's a side yard pavement. It's not part of the front yard request.
So I would have to actually measure the side yard, draw out the required yards, and come up with the actual amount of paving that's in there. Obviously, there are 43 CL, so they have the benefit of R21 zoning, so they have a 16-foot minimum side yard requirement. Anything within the first 16 feet is not permitted. Anything outside that 16 feet is permitted. So we'd have to draw the required side yard and then determine how much paving is in there. I'm looking at the denial letter that we got from the building department, and the plans examiner reviewed the plot plan that was submitted with the application, and there was no indication that she felt that there was an over-paving issue in the side yard. But it can be revisited.
Okay. All right, thank you.
Well, okay, so I'll add to that. It's a very extensive memorandum and denial report. They actually went to the extent of calculating and then updating the calculation for the 51%. There was no evaluation of the side yard that was well visible. They picked out a lot of things, the two retaining walls, that discussion, all those items. It's very specific. And as far as I can see, my initial evaluations looking at, does not appear to be a problem. Otherwise, it would have been picked up on the memorandum. So for it to be introduced right now, it's clear, we know that that's not a part of a front yard coverage, and there are requirements for side yard. However, I don't see that this is in there. So if it is developed, and I can't address that because they spent a lot of time reviewing this. So my professional opinion, that's not an issue. So, but if Blaze, you want to look and see what the percentages is, we could do a quick calculation. All right, so I just want to put that one to rest because I don't, that's not an issue. But again, if we can get the numbers, maybe pull it up, the requirement, and while I'm going through the other items, because we had numerous items, I'll try to go through them as quick as possible. So one thing, I just want to go through Mr. Spellman's testimony here. So there was a survey that was performed back, that I handed up to the board back in 2010, 2012. Lisa McQuilkin started 2008. There's a wall that my client put on the property. It appears it's not an issue, but it is one of the two walls. I don't have the record here, but at one point, my client, I did see a record where they circled the areas in the building department that was a concern. One of them was Mr. Spellman's wall. So at the time when my client was developing his property, he leveled off the area on Mr. Spellman's property also and gave an ending to that wall. But that's Mr. Spellman's wall. So if he needs to do something with that, that's his. But that wall's been there for 12 years. In fact, all these improvements have been here for 12 years. And it's a little questionable that now it's a problem because they've been neighbors all these years and never have said anything that it's a problem. So, I get the particulars. Mr. Spellman is an attorney. I believe he's an attorney, and he has an attorney with him. And they want to be very specific, and I understand that. But I don't think the points that they made have a bearing on this because I worked in a surveying multidiscipline firm for 12 years. I'm very familiar with surveys. I looked and I performed a site inspection on the McQuilkin survey. I saw that wall. There's another wall that's on the survey that was a very low wall, which is actually not even visible because whether it's growth or overgrowth, so the grade is actually grown and adjusted. So it's on the blue, and I'll point it out on here. There's the wall that's on Mr. Spellman's property is, I'll try and steady it, right there. Okay, so that's the one, that's one of the two walls. There was another little low wall, which was like a second-tier wall, almost like a, curb height wall or whatever, which is not even visible. It's either overgrown or been, buried in whatever sort of, yeah, sure.
Mr. Morville?
Yeah,
Because I noticed that one too.
Yeah.
And it's on Lisa McQuilkin's survey.
yeah.
But but it's not on your survey.
Yeah, because I went out there and performed a field inspection to look at that, and that wall is no longer there. I walked over that area. That wall is not visible or is underneath growth or soil, whatever else. It's no longer in that area as at grade at least. So it's
I mean,
below a
just-
grade
Just
level.
to kind of bring this
Yeah.
thing a little to fruition.
Sure.
Because I notice in the survey, I see that 2.3 west.
Yep,
That will be one of the encroachments.
yeah,
At the bottom of the other wall, you know it's there because you put it in yours also. It says .2 west.
yes,
You know
Yeah.
that's an encroachment.
yes, that
I
was,
think
that was the
any
original
approval
one.
that this board may or may not give is going to require any encroachments to be brought
So,
back on the
and
property.
that, it's a small encroachment, so if he has to dig below grade and pull that out, we would absolutely accept that as a condition for, you know, for the review of this application. So that is perfectly acceptable. It's 2.3 feet, and again, it's
And I
something
noticed
that's
that in
now.
both surveys, those are the only two encroachments
Yeah.
that I see.
Yeah, and that other wall is not his. So, like, the wall that we're showing up top here, this is the neighbor's wall. The neighbor had knowledge of it at the time that he built it. It improved his property at that time. It sounded like he alluded to it, it might be on the record, because he wasn't sure which two walls, but it was this wall here and a very low wall, that one that has a 2.3, can certainly be cut back. Again, it's underneath grade at this point, and it was such a small little step there, I don't know if it was for landscaping purposes or whatever else, it can easily be cut back and removed. But it's not visible at this point, in a field inspection that I performed illustrated that.
Okay, I appreciate that, thank you.
So we discussed the driveway. The pipe through the wall, just to, you know, for environmental purposes, that's a pressure relief pipe, which is standard with all Keystone retaining walls. It's not to divert stormwater. Those walls have drainage pipes, so if there's ever any water or water pressure behind it, it's a way to weep through the wall. So that's all that pipe is. It's standard design. Any engineer or architect would be able to tell you that. We talked about the side driveway. That side that he was talking about, just so you know, where this lower retaining wall is on the west line, very heavily vegetated, very heavily vegetated. So when Mr. Basunder, actually, it wasn't Mr. Basunder, oh, it was Mr. Basunder, he said it obstructs views. It's an estate fence. It's not a solid vinyl fence. It's not a stockade fence. It's an estate fence. Like, you could see the pictures. You can see through it in some parts, and you can see there's a lot of vegetation there. You know, the 10-foot fence issue, it's not a 10-foot fence. We got a wall with a fence. That really occurs behind the pool house, and you know, that's where the grade drops off the most there. The talk about the house being too large, the houses within the FAR requirements did not need variances, so that is not an issue. The fact that the neighbors don't like the size of the house, that's their opinion, but that is within zoning, so I understand that. Also, my client, you can call, he has a Ford Excursion, and that's what he parks on the side. It's not like a commercial truck. I just wanted that to be clear, that it's not a commercial vehicle as far as like a box truck or something like that. And issues with deer, he's been in this house, this has been like this for 12 years. There's never been any issues of deer getting hurt or getting trapped or drowning or anything else. So I think we're just kind of, you know, we're just kind of like coming up with things because maybe there's been issues amongst one of the neighbors with my client. I'm not sure.
Okay.
But, you know, it's something that, you know, I think she's owned the house for a couple of years. She hasn't been there the full history, or maybe her mom or family member had owned it. So I'm not sure the circumstance there. But I talked about the driveway. I said, and this is clearly evident in the zoning and on the town zone zoning chart. 12-foot horseshoe driveway is allowed, and it's not included. Once you get over that, everything's included. That's why we have this high number. I've been in front of this board on these driveway issues before, especially sometimes when the lots aren't as wide. And hopefully that'll close everything. All right, so the last thing I want to address is an adjournment. It's up to this board's, decision if they want to adjourn something, but I think we have enough information to show this has been around 12 years. There were permits filed. There wasn't, a variance was not able to be followed up. And the reading of, Mr. Spellman's reading of the application was incorrect. So he said that my client wrote that the difficulty was not created by the applicant or former owner. It circled, it was created. He's acknowledging that, he didn't follow up with the variances. He did file the permits at the time, but, he ran into financial problems, and in part, he's involved with that. So to correct the record, it says on the application, it was created, but we know that being self-created is not a criteria to eliminate or to deny this application. It's one of them, but not one of the only ones that they can create it, and still the board approves this. So I'm sorry, I should have brought a bottle of water, so I'm a little choked up here, doing a little more speaking. So if the board has any further questions, I think I've answered all the concerns that were there. Oh, last thing, I'm sorry, I didn't want to put out there. It would be a hardship for my client for this to be adjourned. He's in contract on the house. We've got things that have been here. Listen, if it was built last year, and that's not an excuse for something not to be done. Wall should be cut back if it's over a property line. Dig it up, take it out, definitely do that. But 12 years, nobody's complained about this. Nobody's knocked on my neighbor's door and said, hey, this is, we don't like this, we don't like your driveway, we don't like all your beautiful plantings and all these things going on in your yard. Nobody said anything. Now he's going to close on the house. We adjourn this, it's the market is what the market is. It's just going to delay things for somebody else to come in and move into their home. And I think that would be a hardship. And I think there's enough information for the board to make a reasonable decision on this. So I would ask that this not be adjourned, respectfully requesting that it not be adjourned so that my client can move forward and close out these things so he can go to court and say, hey, listen, we're doing it and we're getting this thing closed up. So I thank you for your time.
Thank you. Can I have a motion to close the application, please?
I'll make a motion to close this application.
Motion has been made to close the application. It's been seconded. All in favor?
Aye. Thank
Motion carried. Thank you.
Does he want this survey back?
If you want to keep it for the record, that's fine, if you need it.
All right.
The next case on the agenda is case number 18754, Grazia Marino, 31 Stephen Place, Smithtown. The location of the property is the west side of Stephen Place, 575 feet south of Bow Drive East. The property is zoned R15. The applicant is requesting variances to permit environmentally sensitive lands, depth of groundwater less than 10 feet to be altered for a proposed 20-foot by 44-foot in-ground swimming pool, to increase the maximum permitted paved surface in the side yard from 25% to 34%, to increase the maximum permitted paved surface in the rear yard from 25% to 45% for a proposed paved patio, to reduce the minimum side yard from 16 feet to 11 feet, to reduce the total side yard setback from 34 feet to 27 feet for a proposed 48-square-foot outdoor kitchen.
Good evening.
Good evening.
Could I have the applicant, please?
I'm Grazia Marino,
Okay,
and my husband's here, Fred Marino.
all right. State your name and address.
Grazia Marino, 31 Stephen Place, Smithtown.
Okay, thank you. Do you want this gentleman to speak on
Yes,
your behalf?
Dennis will speak on our behalf.
Okay, fine, thank you. All right.
Good evening, Board. Dennis Cook, Curtis Design Group, 1835 Walt Whitman Road, Melville, New York, 11747. We're here before you tonight for several variances being requested for a project that we're proposing for improvements to the Marino's backyard. The house, as it stands, is built on, the way I would describe it, is kind of a mount. And right now, the land in all directions slopes downwards. It slopes towards the neighbors, it slopes towards the back, it slopes towards the front. In fact, from the front to the back, there's almost a 6-foot difference in grade elevation, and in the front to the street, there's almost the same. The Marinos, they would like to utilize their backyard. Right now, as you can see by the photo just before, there's a retaining wall that was built by our previous owner that kind of splits the backyard down the middle. It's built of post timbers, it's rotting, it's falling apart, it could barely hold anything at this point. So, you know, as we know, with the pandemic, a lot of people are staying home, they're enjoying their properties more, and they have, is it nephews or nieces? Nephews and nieces in the area, and they would like to build this as a family space for the nephews and nieces to come, everyone to enjoy. Also, right now, as it stands, because of the way the property is sloped, a lot of the water actually, when it rains, goes towards the neighboring properties. So part of this plan is to kind of excavate down near the house, fill towards the back, make it flat so we could keep the water. All the water is going to go towards the back of the property into an area where it's going to be able to drain. And in the back of the property is part of the Greenbelt Trail. It's town property, a wooded area. Let me just make sure I got everything. On the topic of the outdoor kitchen, the reason for the placement of the outdoor kitchen where it is the way these houses were designed. The kitchen is off to the, if you're looking at the property, you know, the house towards the front, it's to the back left corner. These houses also were built with a cantilever in the back, and there's no door that goes off the back. So the door that leads into the backyard goes off the side. So the reason of the placement of the kitchen there is so that when they're doing things outdoors, when they're entertaining their family members, they can easily get from the kitchen to the outdoor kitchen space and vice versa, without it being far. And then we wanted to keep circulation next to the outdoor kitchen. And, you know, obviously you don't want it too close to the house because there will be a barbecue there will be heat. And we tried to keep it as far away from the property line too, so you don't have an issue with that. I know the fire code states that you need to be 10 feet from a property line at least with any barbecue, so we wanted to make sure that that was accomplished. And that's really it. Is there any questions?
I will ask. Anyone on the board have any questions on this application?
No, thank you.
Thank you.
Planning?
No, thank you.
Is there anyone in the audience like to be heard on this application? No. I have a question.
Yeah.
Mr. Azara, I believe his name is, he's one of the neighbors.
Hmm?
He couldn't be here tonight.
Okay.
He was stating that if, sitting in his property, he sees a 4-foot retaining wall with a 6-foot fence on it? Do you have
On the property now?
yeah. So on his side of the property, there's...
I don't think so.
It looks like there's just a 6-foot fence,
Yeah, that's it.
right? There's no retaining wall,
No.
right? Just a 6-foot fence.
No, there's no retaining wall.
Okay. That was the only thing he was objecting to. He
Okay.
didn't mind
Mr.
anything
Chairman?
else.
I think the letter that you're discussing, I think that the neighbor was actually concerned about the reduction of the side yard setback.
Was he?
Yeah. In his words, he says, by reducing the natural barrier between the homes, reduce the property line, the setback, With the reduction of natural vegetation, I'm very concerned flooding will increase and cause greater damage to my property and dwelling. So I guess he's concerned that there's going to be, there's existing vegetation between the two houses now that are being removed?
No.
Yeah?
There's a couple of varieties, but they're, I think they're state, right? Yeah, that's it.
And you're going to retain all the water on your property?
Yes, yeah, and part of this, right now, the site is actually sloped like towards his property. So we're trying to slope it, make sure it slopes all towards the back at a very gentle slope so that it doesn't go on the neighbor's properties.
Okay, thank you.
Thank you.
Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried.
The next case on the agenda, case number 18755, Lori Gaskin, 17 Willow Street, Smithtown. The location of the property, the north side of Willow Street, 200 feet west of Lawrence Avenue. The property is zoned R10. The applicant is requesting variances to reduce the minimum side yard setback from 12 feet to 11 feet, to reduce the minimum rear yard setback from 35 feet to 26 feet for proposed rear additions totaling 42 square feet.
Good evening.
Hi, I'm Lori Gaskin, Gaskin. I reside at 17 Willow Street, Smithtown, New York, and I have Megan from Mancini Architecture here on my behalf.
Fine. Thank you. Good evening.
Good evening. My name is Megan Lucas, Lucas, Mancini Moy Architecture, located at 222 Middle Country Road, Suite 314 in Smithtown. The subject property for this application is 17 Willow Street in Smithtown. The two-story single-family residence is located on one of two properties owned by the applicant, just east of the Smithtown Fire Department. We are requesting a variance to reduce the rear yard setback from 35 feet to 26 feet, and the side yard from 12 feet to 11 feet, for proposed rear additions totaling 42 square feet. Just some background information on this property. The existing residence was built in 1932, prior to the requirement of a CO or the current zoning setback requirements. Both setbacks we are requesting are already pre-existing conditions on the house. The house already sits 11 feet from the side yard and existing 26 feet from the rear yard. The original footprint of the house has a small 32 square foot addition off the rear that we would just like to square off with the side of the house to create a more functional kitchen space for the applicant. We don't believe this request will be considered an undesirable change in the character of the neighborhood or a detriment to nearby properties, as its conditions are mainly existing. As you could see by the size of this request, it is not substantial compared to what the board sees at all these meetings, weekly, monthly. It also does not have an adverse impact on the environmental conditions of the property or the neighborhood. Thank you.
Okay, thank you. Anyone on the board have any questions on this application?
No, thank you.
Planning?
No, thank you.
Anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Thank you.
The next application on the agenda is case number 18756, Stella Lavoie, 31 White Cliff Lane, Wisconsin. The location of the property is the east side of White Cliff Lane, 162 feet south of Meadow Court. The property is zoned R10. The applicant is requesting variances to reduce the required setback of a fence to a retaining wall from 4 feet to 0 for 2 retaining walls A and B, to increase the height of a 6-foot fence on top of a 4-foot retaining wall from 6 feet to 10 feet for 2 existing retaining walls A and B, to permit environmentally sensitive lands to be altered where depth of groundwater is equal to or less than 10 feet for the existing retaining walls.
Good evening.
Good evening. I'm Stella Lavoie. It's L-A-V as in Victor, O-I-E, 31 White Cliff Lane, Nesconset, 11767.
Thank you.
And Mike from Inspire is going to speak for me.
Fine. Thank you.
Thank you.
Good evening, Mr. Chairman, members of the board. For the record, my name is Michael Morbillo, architect, Inspire Design Group, offices at 273 Lake Avenue, St. James, New York. So the application before you this evening is for another retaining wall with a fence on top. The fence is not set back from the edge of the retaining wall, the required amount, so it then gets included in the overall height. So the first portion of the request is for 6-foot stockade fence on top of the wall. The fence is located on the east and south property line. And we're also looking to reduce the setbacks for, actually, it's for groundwater. We're in an area known for groundwater, high groundwater, and which is considered as environmentally sensitive. We were notified last week from environmental that we needed to obtain a soil test to determine groundwater height, so they were not able to issue SECRA on it before the meeting, so I understand that any decisions would have to be held for that. My client's aware of that. She's having a soil test performed this week. But from what I can see, due to lower elevations, there's no apparent surface waters or anything else. My client also has a basement, so we're not looking to see that, we don't see that any high groundwater will be an impact on the application. What we have is, the wall, there's a drop-off in the grade behind the house. One of the neighbors, the wall was actually built last summer, so it was built without benefit of a permit. My client is new to the area, moved from Nassau County, and wanted to level off the property. So she did that. She had to file didn't realize that she needed to file permits for it, and a complaint came in very recently from a neighbor, and therefore we had to file permits for it. She's also getting permits on other small things, a shed, which didn't require any relief, and some fences that are on the property but are in an allowable area. The wall, as far as we could see, the applicant approached the rear neighbor and the side neighbors surrounding her, except for the one neighbor who complained, and they do not have any issues with the wall. But basically what you're seeing is a approximately 4-foot, from about 32 inches, 48-inch high wall with the fence placed on top. The fence was supposed to be placed back further. And that is the request before you tonight. If the board, it's been there since, since July, August of last year. So there's not been any environmental impact. There hasn't been any adverse runoff or any other issues with the wall. There's the neighboring homes, especially on the Toll side, there's a big open area behind the home. The neighboring property, the house is set off way to the distance. It's sort of like an out parcel in the original subdivision, so there's not, it doesn't affect anybody's, nobody's looking out and seeing that wall from the neighboring house, because the neighboring house is actually located to the north, and that wall is on the east. So there's nobody looking at the taller wall. There, you could see the one on the bottom, the south retaining wall, that goes from approximately 4 foot in height to about 6 inches in height, and that's a triangular wall. So that's the one that abuts one of the neighbors who had complained. But there's a lot of landscaping in the neighbor's side, so it's not very visible at all. And it does meet, the wall meets the setback requirements, but we're here really for the fence on top of the wall. And if the board has any questions at this time, I'd be happy to answer them.
The large retaining wall with the fence on it,
Yeah.
that's what I was referring to before.
Yeah,
I got
yeah.
my cases mixed up,
So,
because I believe the next door neighbor
yeah,
objects to it.
the neighbor here had objected to the wall. So they face that triangular wall that goes from about a foot high to about a little bit less than 4 feet in height.
The retaining wall, is that where the grade is in your client's backyard?
Yes. Yeah,
That's grade.
That's grade,
And
yeah.
then she's putting, like anybody else, with a 6-foot fence up.
Yes, yeah.
That fence, isn't that facing the wrong way?
Well, there's another fence, it's a little bit hard to see. There's actually another fence at the bottom of the wall, which is the neighbor's fence. So it's within her yard, but I don't know if there's rules when it's actually a fence within a fence. So she put the fence there because, she got grandkids, she didn't want them going over the edge of the wall, obviously, so it's more of a guard. But there's another fence at the bottom of the wall, a chain link fence, which is illustrated on the survey. So I'd have to, I don't think there's a requirement for the wall, for the fence to face out if it's like an interior fence. As far as I know, I don't know any zoning code that prohibits that. Okay.
Is it facing the wrong way? It has to be changed.
Yeah, what they call the finished side
Yeah.
has to face the neighboring property.
Okay.
Yeah.
All right, so my question would be, is that a zoning requirement, or is that just sort of like a common
I think it's
courtesy
in the
requirement?
regs, when you go and you look at the fence, installing fencing and the fence
Uh-huh.
requirements,
Yeah,
especially if there's a pool in the backyard, that's,
Yeah.
a big concern that somebody
Yeah.
can't climb over the fence.
yeah, so, again, there is a vinyl fence that they had put up, which was, they got a permit for, they've gotten a permit for it. And then there's a chain link fence that surrounds the property. And then the neighbor has a fence over here, and then there's another vinyl fence that's over there. So I don't see it as a pool safety issue. Even if they were to put a pool in, there's nothing to climb over. So if the concern is that there's a code requirement and they got to reverse the fence, then they have to comply with code because that's not on the request. So they would certainly comply with whatever the code is on that if they have no choice, especially since it's not in the request.
From your client's, again, the large retaining
Yep.
wall. From your client's retaining wall
Mm-hmm.
to the neighbor's retaining wall,
Yeah.
how big is that space in there?
You're saying on the northern side of the property over in there?
Yeah, what,
That space in there, well, this grade is higher. So what happens is that if you see where the pointer is by the shed, and there may be a little, I think there's a picture, one of the pictures, it actually runs into the grade. There's a slope here. There's an existing slope. And we might be able to catch the end of it. We'll see in one of these, maybe.
can you bring
This
up the
group here.
picture? Right. Yeah, right
So
there.
it's right, this actually is the end of the wall because this grade is coming up and the neighboring retaining wall is at a higher elevation. So there's actually a slope that's there. So
That's your client's property, though.
this is my client's property, yeah. That's my client's property. There's another retaining
the
wall.
middle.
Yeah, yeah, in the middle. That's, if you go back to the survey, just to clarify, the neighbor has a retaining wall, which I assume is permitted. It's on their property. My client's, and then there's a natural slope down from here. So my client's retaining wall actually dives, there's a level area here. It actually runs into the hill. So there's no gap or anything there. It's like, there's almost like a little bit of a level area you can kind of walk in that spot to explain that. So there's no need for these to be connected together because there's already a natural, this retaining wall is at a little bit higher elevation. So the top of my client's retaining wall, which is about 32 inches here, goes, basically dives right into the side of the hill. And it's entirely on their property. It's not off. When they came in, there's an existing chain link fence. The neighbor behind them whose house is actually, you know, a little bit further away. I have it on here about 120 feet away. That fence was already there. They built the retaining wall inside. For guard purposes, they put a 6-foot stockade fence on top of that. And that's where the real issue is. If it had been, I guess, well, it couldn't be much. I think it'd have to be like 3 feet or something to be able to possibly conform.
All right,
Okay?
thank you. Anyone
Sure.
else on the board have any questions?
No, thank you.
Planning?
Just want to mention for everybody's information that the resident located at 33 White Cliff Lane, which I believe is the neighbor to the southeast of this property, down in the lower right-hand corner, they have a concern about the height of the wall and the height of the fence. They feel that it's impacting them because they're now looking at basically a 12-foot high wall and fence in their backyard. And I think everybody got a copy of that letter. So, just to put it on the record.
All right, thank you.
All right, I'm sorry, I'll step back.
Let me just see if
Yeah,
there's...
yeah, go right ahead, sorry.
Is there anyone in the audience like to be heard on this application? No? Go ahead, Mike.
I'm just gonna hand, I didn't label these, but I'm just gonna hand them in for just quick reference, so you can see the neighbor's property. Okay.
Is that it?
Yeah, so, yeah, that's it. What you're looking at is actually, there's one picture, you're actually looking at the space between the retaining wall and the neighbor's. There's another fence that's, the neighbor has, this chain link fence. You're seeing a picture, looking at the fence. It's very heavily vegetated area there. And there's also a view from like my neighbor's house or deck area, looking down. You can see very heavily vegetated. I mean, you know, the wall over here, again, is, I'm sorry, it's about 6 inches in height. So with the fence, it's about 6'6". And then, yeah, down over here, so what you're seeing is it goes from about 6 inches of height to just about 4 feet in height over in this area. The neighbor's yard is here. They're very heavily vegetated here. I mean, listen, if it was a mitigating circumstance and they wanted us to plant something here, you know, they'd do it. My client would do it, but I don't think it's going to do too well because there's all these evergreens and everything that's illustrating those pictures. I don't think they're going to survive all the well. But if the board thought that, you know, there was a softening needed over there to mitigate, we do it, but that's a picture taken a couple of days ago. There's a lot of vegetation along the property line, but if more vegetated needed to be added or was a condition, we certainly would agree to that condition.
Okay, thank you.
Sure.
Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor?
Aye.
Motion carried.
Thank you.
Thank you.
Have a good evening.
The next case on the agenda is case number 18706, James and Margaret Kilker, 57 Dorchester Road, Smithtown. The location of the property, the west side of Dorchester Road, 294 feet north of Cedar Ridge Avenue. The property is zoned R15. The applicant is requesting variances to reduce the minimum side yard setback from 16 feet to 5 feet and total side yards from 34 feet to 29 feet for an existing 80-square-foot shed.
James and Margaret Kilka, are they here? Look, this will be the fourth adjournment coming up. This will be the fourth and final one. I'll do it in September.
Okay.
But isn't this one that they haven't shown?
Yes.
They haven't shown up with all
No.
this?
They haven't been here the last 2 times, John, so I don't know if they're here tonight. All right. This case is going to be adjourned to
Do you need a date?
September 27th.
Is that a final?
That's the final.
All righty. The next case on the agenda, case number 18753, Patricia Patterson, 12 Pinewood Court, Wisconsin. The location of the property is the north side of Pinewood Court, 590 feet east of Midwood Avenue. The property is zoned R15. The applicant is requesting a special exception to permit temporary living quarters for a parent, a variance to decrease the minimum rear yard from 60 feet to 57 feet for a proposed one-story, 827-square-foot addition.
Good evening.
Good evening. My name is Patricia Patterson. I reside at 12 Pinewood Court, Nesconset, New York.
Would you like this gentleman to speak on your behalf?
Yes.
My name is Ed Roland. I do business as NDA Construction at 192 Smithtown Boulevard in Nesconset.
Just spell your last name so we get it correct for the record.
Rowland.
Thank you.
I'm here to represent Patricia for actually a change of use for a mother-daughter apartment of 827 square foot gross square footage. And the only variance we need for that is the rear yard, about 3 feet by the width of 25. So yeah, about 27 square feet. Doesn't seem like a big encumbrance to me. There's a unused strip of property behind her house, and then there's Tacan Elementary behind that. Her neighbor to the left, we're 16 feet on that side, and we've met that requirement, and we're still within the front yard setback. It's one story. Mom's gonna move into the apartment. The kids just took over the house, and she's due for a baby in September.
All right. You're 16 foot at the one corner at the bottom, but you're 20 feet up at the top.
Correct.
Yeah.
So we've got a lot of yard. We're only asking for a few feet in the back and the variance for the mother-daughter.
Right. Okay. Thank you.
All right, thank you.
Does anyone on the board have any questions on this application?
No, thank you.
Thank you.
Planning.
Mr. Chairman, the Planning Department prepared a planning advisory report. Based on the review of the application, we recommended approval.
Thank you. Is there anyone in the audience like to be heard on this application? Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Thank you.
Ed.
Okay. Before we start, John, we're going to take a 5-minute break.
Case number 18683, 189 Main Street, KP LLC. 189 Main Street in Kings Park. The location of the property is the southwest corner of Main Street, New York State Route 25A, and Park Avenue. The property is zoned CB. Excuse me. The applicant is requesting a certificate of existing use for a filling station, a variance to permit an accessory structure in the required front yard, to reduce the minimum front yard setback from 10 feet to 0 for a proposed 1,276 square foot fuel canopy, to reduce the minimum parking from 19 to 4 spaces, to reduce the minimum parking setback from the front property line from 6 feet to 0, to reduce the minimum landscaped area from 5% of the lot area to 0.
Good evening.
Good evening, Mr. Chairman, members of the board. My name is John Armentano. I'm an attorney with Farrell Fritz, representing the applicant. I also have with me Gino Tedesco from R&M for any technical questions that you may have. This is an application that's been on before. We have revised the plans. I have a little bit of information to hand out to the board, so I'll do that.
You can fix your collar. You're on television. You gotta look presentable.
We'll take you through the application, and we'll go to the sheets that you may need to look at.
The plan, just a... All right, go right ahead.
Sure, thank you. As you know, we were here last March, and we appeared before the board at a Zoom meeting, and the comments were made to revise the plans. We have done that. We have submitted revised plans to the planning department on May 9th, which reduced actually several of the variances, and I believe made the site improvements better for the site, and we hope better for the neighborhood and the community. One of the significant changes, and I'll just take you through the application packet so you are familiar with it. If you look at the booklet, the property, as you know, is located on Main Street in Kings Park. That's Exhibit 1, in an area of Kings Park that they're on 25A, that is illustrated in an aerial photograph on Exhibit 2. The road was widened, and we are very close to the front of the building is close to the property. It does constrain the site. What we did, and you'll see an example in Exhibit 3, there's a colorized version of improvements that we've made to the property. That may not be on the screen in front of you. That's why we did, oh, it is on the screen in front of you. We colorized it for your booklet, so you'll see that we increased the landscaping on the property to 15%, which is above the 5% requirement for this section of the code. We were originally at 0%. The property was completely paved, but based on feedback from staff, we have modified the plan significantly to both soften the site and meet the town requirements for landscaping, as well as curtail the parking that has occurred on the property on the sidewalks. I know that was a major concern. So what we have done, and it may not be that clear on what's on the screen, but in the colorized version for the board, and I can submit it to any of the, I'm sure there are people here that want to see it. I
Why
can
don't you
also,
take the easel
sure.
and put it over here facing the people so they could take a look at it, since we have it in the book. Yeah, that's,
So basically what we've done
I'm sorry. You have to use the microphone. You can talk to us.
Okay.
They could just refer to that
Okay,
drawing,
sure.
that's all.
And this was required and suggested in the staff report of March 21st, 2022. If you don't have that in front of you, I have a copy of that I can also hand up. Would the board like to see that for comparison? If you have your staff report, I have it here if you want it.
You want it?
You're fine?
Yeah.
Yes, oh, you want to see it?
Yeah.
So if the board turns to the last page of the staff report, there is a colorized version of basically what we have done as well. We tried to mimic it as best that we could. What you'll see, and if Juno, you can point to that, this matches up, I think, very nicely to Exhibit 3 in your booklet, which shows the plantings that we have done. So you have plantings on this is the north side along Park Avenue, if that's the north. Yes, so we have planted, that remains, there's increased landscaping there, mostly turf. There is also on the middle, there's a middle island between the two driveway entrances. That's there, which is being planted with landscaping and 2 trees. There are 2 trees which do mimic what the staff had recommended. We then have additional planting. We have a curbed area here at the south to prevent the issue of parking on this sidewalk. And then we supplement the planting on the corner as suggested by the staff report. The trees are not located as it would be difficult for them to do well here, in our opinion. So we have landscaped it basically to soften the site. And what we have highlighted in yellow is the rear yard, which is existing vegetation that we're not going to touch. So it is, for what it is softened and it is landscaped. In addition, We have a larger site plan pullout in the application, which is Exhibit 4, is showing the canopy. This is the architectural rendering of the canopy. We will comply with the height requirements of the town code. There is no signage on the canopy. It is a canopy very similar to what is on the corner of Edgewood and, I believe, Main Street in Smithtown. The additional, we have site photographs at Exhibit 5 showing the existing conditions. These are going to be improved, and I think it will make the site look much better. It will be, drastically improve, I believe, the frontage of the site. It currently is rather bleak, and it will be improved with the plantings. In addition, Exhibit 6 does show 2 other business uses in the vicinity and the sump, which is across the street. So it just gives you a flavor for the existing conditions. I'm sure you're familiar with it, but I find these booklets to be helpful for that purpose. We have also submitted, as Exhibit 7 and as part of our application, the property record cards for the property, which clearly indicates its use as a gas station since, I believe, the early 50s. Part of our application is seeking a CEU, which is required because of a recent change in the code, which no longer permits filling stations in this section of the code, but it had for a very long time. So that is why those exhibits are in there. That shows you our proof for the CEU status or request. Exhibit 8 in our booklet is in a case 16364, which was approved by this board in March of 2011 to allow for the existing pylon sign to remain at the height of 20 feet. But what we are doing as part of this application is to relocate that pylon sign at the approved height. So we will be lowering the sign, so we will not need any variance for the size of that sign, the height. The staff recommendation previously was for a ground sign, and that does not work well with the site operations, just due to the mechanics of moving on the site with vehicles. So, and with staff meeting, we had met with staff, we discussed the relocation of the sign, editing at the proper height. So I believe that does not need a variance, even though we have one for that height. We will relocate it at the appropriate height. In addition, so that, in terms of the call of the meeting, there is a reduction in what our variants are for this evening. We obviously need a front yard setback of 0 feet because the canopy will sit at the property line. We do not need the variance required for the minimum landscaped area of 5 feet because we exceed that to 15%. Again, we need the variance to permit a fuel canopy in the front yard. That is the only location of the front yard. That is the typical location for this type of use. We have increased the number of parking stalls to 9. I know that was an issue previously. We have removed the storage that was on site and reconfigured the parking to have 9 spaces instead of the 4 that we previously proposed. That is a variance from 19. So whereas a 10 stall shortfall, but we did increase the parking on site to address the concerns of the neighborhood and the board. Again, we do have a minimum setback on the property line for the parking, which is 6 feet, and has to be 0 because we are on the property line with the parking. And we are also requesting a CEU for the existing use of a filling station, which has been in place for a number of years. They do have, just for reference, and I'll hand this up, an approval of this board in October of 2016, where they did approve a very similarly situated property, although it was in a neighborhood business. It was for the property located, as I referenced, on the corner of Edgewood and Main Street. That's a Speedway now, and it has very similar variances to ours.
Thank you.
So at this point, you know, I can turn it over to Gino if you have any technical questions. I do believe we've met the standards for the 5-part area requirements test. I can go into that in detail now, or we can hear from the public, or you can ask us questions and we can respond as well.
I think we have enough, right?
I just had a couple questions. One, the size of the canopy, is it still 1,276?
Yes.
Okay. And then the zero setback for the parking, that doesn't apply any longer?
That
Or
may
does
not,
it?
if we are off the site, if we are,
The handicap
Handicap
spot
spot.
goes to zero? That's the one on the corner?
correct, yes.
Okay, thank you.
And the other thing I forgot to mention, we are removing the ice machines from the property. That was another issue that we were required to do. So that will not be there, so we're not seeking a variance to, they will be gone.
Okay. Anyone else on the board have any questions? No, thank you. Planning?
As Mr. Armentano stated, we did have a meeting, we did go over the plan, they did a very good job of revising it and substantially meeting all the recommendations that we made for landscaping, for setbacks of parking. Just two things I'd like to mention for Mr. Armentano's benefit. The first thing is, in looking at the elevation plan for the proposed canopy, I still see that it's proposed at a height of 19 feet 2 inches. I know you did mention that they planned on meeting the 18-foot limitation.
That is correct.
So I just wanted to make you aware of that. And the other thing was, on this revised plan, the colorized plan, it does show the relocation of the pylon sign. It doesn't make mention of the 5-foot required setback, so I just wanted to put that on the record so that they would be aware when the time came.
Of course, we understand that. And the other item I did also forget to mention was the outdoor lifts are also being removed, which is how we accomplished getting more parking on the property. So all the requests of staff were met, and that is how we increased our parking.
Okay.
Thank you.
All right. Is there anyone in the audience that'd like to be heard on this application? Okay. Now, remember, everything that you said last time is still on the record, so if you have anything new to add, that's great. But come on up one at a time. Good evening.
Hello, my name is Kristen Matejka, Matejka. I live at 4 Park Avenue in Kings Park. So yes, I understand my previous comments have been noted. I did just have a question. So I appreciate that the parking was increased to 9, but I still feel as if that is not sufficient for the amount of business that this that happens there. And you know, if any of you drove past today, there were probably, I don't know, 6, 8 cars parked in front on the sidewalk, in front of the variance sign, in front of the no parking signs. You know, all up 25A, all down Park Avenue South. My concern again is just even with 9 spaces, I don't understand the reduction in parking. I don't have a problem with the canopy. I mean, sure, I want the guys there to not have to stand in the rain, of course. But I don't understand the reduction in parking. So if they could adjust that, that'd be great. I appreciate the increased landscaping. My concern is the walkability of it. You know, we're going into the downtown revitalization, and that is a very wooded and scenic part of the town, except for this property. And right now, it's very bleak. I appreciate the 2 trees. That's great. My concern is when people walk from Park Avenue South into the downtown area. Right now, they encounter cars. They have to walk onto 25A or walk by the pumps to get by this corner to get into the downtown area. So my concern again, too, is there should be some more accommodation for people walking into town.
Okay.
Okay, and I think that's it. Thank you very much.
All right, thank you. Who's next?
Good evening.
Good evening.
My name is Terrence Ryan. Last name is Ryan. Good evening, members of the board. I live on 8 Park Avenue. I previously spoke at the
Last meeting.
online thing, or whatever it is. My concern is like my neighbor, the amount of parking. Right now, the operator is parking on the sidewalk, parking in a no stopping zone. The property in question is at the bottom of the hill on 25A. The cars coming down that hill, while they're supposed to be doing 30 miles an hour, I sincerely doubt you could ever clock one coming down at 30 miles an hour. The addition of the canopy, while maybe recommendable, if they do not have pump attendants, there may be a backup on that Park Avenue South as well as 25A, which means the cars coming down that hill may impact cars waiting to get into this gas station. This would be a safety concern. This would be a potential threat to, people who are using that highway. The other thing is that as it stands now, he is ignoring the no stopping sign in front of his own business. Today, the zoning notice had a car parked in front of it and in front of the no stopping sign. This is not some kind of business that is looking out for the betterment of the community. This is a business that is only concerned with itself. And as such, that if there is if there's more parking out on the street, the situation will get worse. As it stands now, his employees are parking on 25A because he doesn't have room for the cars. Now, if you add the canopy, you take away more spots. I don't know what kind of landscaping is going to be involved. I do not consider grass to be landscaping, but it's not going to change much, and it's only get worse. And it's only going to hopefully will not lead to injury to someone who's coming into town. Thank you very much.
Thank you. Good evening.
Good evening. My name is Thomas Delaney, Delaney. I live at 53 Park Avenue. I'm not going to reiterate what they said. I'll make it quick. I moved in near a gas station. It's what it is. I accepted it. I moved in. I can't imagine why they won't want to go from 19 spots to 4. The only thing I'm afraid of is that they have future plans for the building, but they're limited by the parking. But if they get over that hurdle now, they won't have to do anything later. On any given day, between Park Avenue, Burr, 25A, the sidewalk, and the parking lot, there are no less than 40 cars related to that gas station. I would like to give it to you if you like. I have 9 separate days, only in the month of June, one being today, of photos of the absolute mess of parking for that gas station. Different times of the day. I work at night. Some of them are 7 in the morning when I'm on my way home before it's open, and there are still cars parked on the sidewalk from the night before. So I have 9 days. I agree with everything they said. We'll keep it short. 9 days worth of pictures for you guys to take a look at.
Okay. Thank you. Anyone else in the audience would like to be heard on this application? Would you like to come back?
So to address the parking situation that's being raised, as you can see, the requirement of the site is to have 19. Our site configuration is what it has always been. This is an application for a CEU, which means that the property was used as a gas station prior to the variances, prior to the code being written that would require 19 stalls on this property. What we have done with this site is eliminate all other uses but the existing convenience store, and we've place everything else that can be a parking place, a parking stall. That's why we have maxed it out. We are maxed at 9. We cannot fit any more stalls on this property. That's why we're seeking the variance from the code, although I would argue that with the CEU being the primary request, traditionally CEUs allow for the use to remain because it predates the zoning, which would require further requirements and further limitations. That may be variances for parking, et cetera. The use and/or what was on site is approved for its point in time that it existed prior to the zoning code. But to also answer some of the other concerns, so we have parked as much as this site can fit, unless we were to place double-decker cars. We can't, we're not gonna put lifts, so there's no way to fit more cars. I do understand that it is an operating gas station. It is under new ownership. The owner has to comply with the no parking signs. That is an enforcement issue. That's not a variance issue for this board, as I'm sure the board is aware. But just to be clear, the owner is aware that of the requirements that are here. The correction can come from the town for the off-site parking. That is a no parking zone. They should be ticketed. I'm not saying that that's the solution. You cannot vary that, nor can we. The site operates as it operates. The other issue that was raised is the canopy. The canopy is not affecting parking stalls. The canopy, this is currently a 2-pump station. It remains a 2-pump station. We're just putting an overhang on top of it, so we're not affecting maneuverability whether or not there is an attendant. It is a typical gas station that has existed since the 50s in this general configuration. So the issue of maneuverability has not changed. The building has been where it has been. The pumps are where they are. 25A was widened many years ago, which has further constrained the size of the property. So that's a reality that we have to address and live with. So to answer the other questions, not stopping at the stop sign, we all know that's not supposed to be done. I assume that the owners will correct that. We will take that back to them. The issue, again, is that we can fit no more parking stalls on this property to address that issue. This is the limitation on the site.
I have one question.
Yes.
How many employees do you have during?
I don't know that answer myself. I can find out. Give me a minute. We sold 7 is the number of employees. I don't know if they work there at the same time. I know this is an active garage. They may park off-site where they can. I'm not saying, if there are issues in the neighborhood with the parking of cars on residential streets, the town has the ability to prevent parked cars from anyone. So I'm not suggesting, that may be done at the town board's request. I am not clear. I have not seen the pictures of the parking. I've been at the site several times myself. There may be other cars not associated with this gas station that are on the streets. I don't know how you can prove that, but I do know that there are other cars parked that are not connected to the use on the site.
All right. Back in March, one of the big issues is the cars parking on the sidewalk. The gentleman just gave us a whole series of pictures, various days, various times. The cars are still parking on the sidewalk. How are we going to correct that?
I think part of that is being addressed by the landscaping. There will be curbing. They cannot park on the sidewalk. If you look at the site, and if you compare it to where, obviously they are on the sidewalk because it's a paved area and it's a convenience that they are utilizing now. But I believe when you place what we have improved the site with, which you can see as the colorized version on Exhibit 3, it eliminates, they're not going to park where the trees and the drive aisle is, or I'll call it the landscaping island. There's a limitation on the west or the north. Parking in front of the canopy doesn't make a lot of sense for access for gas. It doesn't make sense. And in addition, they would be, there's a sidewalk there, so we will not park there. You want to stripe it with no parking. If that's something that the board wants to do, it looks busy for the site, but if that's something that the board would like to have, I think that's an accommodation we can make so that it becomes very clear that you're not supposed to park in those areas. To the extent we can stripe that area, we will do that.
I have a question for you.
If they can't avoid parking on the sidewalk while they have something pending with the town, which you would think that they would be on their best behavior while they have something pending before us, what makes us think that they're going to not park on the sidewalk if the smoke clears here?
Again, if it becomes an issue you could have a covenant that it will not park there. There can be an enforcement measure at the town. What I am saying to you is that I understand what you are saying that is happening now. I think we can limit that activity, and if it becomes a covenant of this board, then is an enforcement mechanism that you would have, that the town attorney would have to enforce that. So we can give you that, and if that would address these concerns, that's the only way I could really envision a way to control that.
So one of the things I notice about site design as it currently stands is that the reason it's real easy to park on the sidewalk is that there is no real delineation between sidewalk and parking lot.
Correct.
Was it contemplated at all to create curbing along the sidewalk that would kind of make it impossible to park there?
We can do that. I believe that's something that we
I
would
think
be
that might
willing
be
to
the
do.
best solution, so that it delineates the difference between what is sidewalk and what is parking lot, and would go to Ms. Matika's concern about creating that path, getting from the west end of town through town, and what seems to be a walkable corridor, which, you know, with the addition of the trees and the addition of a proper sidewalk, would actually accomplish that. One of the other things I was thinking was, if the landscaping, you know, I noticed in the town's rendering, there was a tree on the east property line. I noticed, I can't tell what the landscaping is on this one because it's just all colorized green. Is there any trees going on that property line?
We can add that additional, you're talking about I'll say it's the corner, if this is north, the south east corner. Yes.
No, what will be the northeast corner of the property?
So not currently shown in the towns either? Because the two.
No, I noticed that in the town's recommendations, it showed, I believe, 3 trees along that property line.
Right, you're referring, I'll point to it here, you're referring to this one.
Correct.
Yes, that can be added. We can, I think the idea of the curbing on both sides is a very good idea. We can address that. If that's a part of this approval, we will install that, which I agree will stop the car wheels. It's too easy right now to do it. So if that's there, that would constrain where you would park. That's something we would be willing to do. And that tree can also be added to the landscaping plan.
And then the only other question I had was, currently 3 repair bays?
In the building, there are 5 in the building.
5 repair bays in the building?
That's what I
And it will
understand.
remain 5 repair bays, or is there going to be an expansion? 4?
We are reducing to 4, but the size of the building stays the same.
Right.
Right.
So reducing to 4, so eliminating 1, which in theory should reduce the load required for all these cars parked around, because in my experience, it seems that most of the cars are cars that are either in a state of repair or being dropped off to be repaired.
Correct. That's right.
Thank you.
Anyone else have anything? No? All right. Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application. It's been seconded. All in favor? Aye. Motion carried. Thank you.
Thank you.
We put the pictures in there.
The next case on the agenda is case number 18748, KPE2 LLC. The location of the property is the northwest corner of Old Northport Road and Lawrence Road. The property is zoned R21. The applicant is requesting a variance to alter environmentally sensitive lands, slopes greater than 15% within the subdivision known as KPE2 LLC number 1192.
Good evening, Mr. Chairman, members of the board. My name is John Zolo, 12 Manor Road, Smithtown, New York. I'm here this evening on behalf of the applicant, KPE2, seeking a variance to alter environmentally sensitive slopes. I presented to you a shrunken down version of the site plan that's been submitted to the Town Plan Department for consideration, which ultimately will go into the planning board for subdivision. And also submitted 8 photographs, just kind of giving you a layout of what the site looks like. And it's tough to take a picture that would do it to kind of depict it any better than just, you'll see some trees and shrubbery and some small hills. So I just want to go through this application with you, and then I have Mr. Michael Marinis from Barrett Bonacci Van Weel, a licensed professional engineer. He'll walk you through the site plan once we get to that point. Some of the photos that I presented are on the screen as well. Tonight's hearing is to consider the variance request to alter environmentally sensitive slopes that are greater than 15% within the proposed subdivision known as KPE2 LLC. The property is located at Old Northport Road, Kings Park. It is the northwest corner of Old Northport Road and Lawrence Road in Kings Park. The property is zoned R21. R21 is single family. The property is approximately 25.9 acres. Suffolk County Tax Map numbers 844-2, lots 9 and 10, and 845-4, lots 28.1, 29.1, and 30. A portion of the property, 20.9 acres, was the subject of rezoning from light industrial to R21 before the planning board and ultimately approved by the town board on December 17, 2019. The town board granted the petition for change of zone from light industrial to R21 single family. In furtherance of the rezoning, there was an environmental impact statement prepared, which was adopted by the town board. The resolution was adopted with 6 conditions. The town board had issued a secret positive declaration on July 15, 2014. On December 11, 2018, the town board accepted as complete for purposes of SECRA review the final environmental impact statement and issued a SECRA finding statement and conditions on March 21, 2019. The SECRA findings state approval of change of zone petition 2013-05 is the action which minimizes adverse environmental effects to the maximum extent practicable, including the effects disclosed in the relevant environmental impact statement. My client intends to develop the site for single-family dwellings. On December 21, 2020, as per the conditions of the rezoning, the applicant filed a cluster development plan for the property. They initially had proposed a 42-lot cluster conceptual development plan, which was prepared for the final environmental impact statement. Currently, after numerous meetings, discussions with planning, and various amendments to the initial cluster plan, the clients had submitted a plan with 39 residential units. Thereafter, after more meetings with the planning department, the site was designed to have 36 lots. My client agreed with the planning department based upon the various changes to the proposed subdivision to accept 36 lots and not go with the 39 lots because 39 lots would have required them to come to this board for additional variances to seek the 3 additional lots. So they opted not to do that. So the planning department, after review of the plan that's submitted, that is going to be submitted to the planning board, required us to come to this board to seek variance to alter environmentally sensitive slopes. That's the only application for variance that's being presented to the board tonight. And the proposed residential development is on the eastern portion of the property. There'll be significant buffering from the residential zone property to the west, which is Linden, and the recharge basin for the subdivision will be on the eastern side of Kings Park Road, on the property that fronts on the corner of Lawrence Road and Old Northport Road. So, I don't know if you can, I don't know if you can see it. So, basically, you've got, as you look at the map, and Mr. Marinas will go through this, we have 36 lots, and starting, everything is west of what is a paper street known as Kings Park Road, and that's a dividing line. To the east of that is a property that's commonly referred to as the Jesuali property. So all the development of these 36 lots is clustered as required by the town and the planning department, the planning board, and there will be a significant amount of buffering on the property and property that will remain in its natural state. The subject property is R21. The parcel to the north is zoned R21. The parcel to the south is zoned R21. The parcel to the east is zoned R21 and light industrial. The parcel to the west is zoned R21. The current site is partially vacant precast concrete products business. It's industrial as well as a former sand mining operation. The parcel to the north is vacant residential. The parcel to the south across Old Northport Road is a greenbelt, then residential development. The parcel to the east is currently vacant and has industrial uses and was formerly a mining and transfer station. To the west is vacant property and single-family dwellings. The applicant is seeking variances from this board for the planning department approval to go to the planning board for preliminary approval of the subdivision map. Based upon the plan that was input with the planning department after discussions, meetings, we came up with a plan that's presently before this, that the board has on the screen, and I presented you copies of. The overall lot size is 25.9 acres. The proposed residential lots will be quarter-acre lots. The property that will be affected by the variance request to alter environmentally sensitive slopes is approximately in total 1.5 acres. There are 5 lots that are impacted by the variance request. Those are lots number 9, 10, 11, 12, and 13 on the proposed preliminary subdivision map. There will be 5.28 acres remaining as a recharge basin, which is down towards the Old Northport Lawrence Road intersection, and there will be 7.26 acres remaining as open space. There's significant buffering that is going to be between the proposed residential development and Linden. So that's basically the overview of the application. At this time, I'd ask Mr. Michael Marinas from Barrett, Bonacci, Van Weel to come up and just talk to you about specifically where the environmentally sensitive slopes will be altered and how we came up with this plan. Mr. Marinas?
Good evening.
My name is Michael Marinas, licensed professional engineer in the state of New York. I work for the firm Barrett, Bonacci, and Van Weel, 175A Commerce Drive, Hauppauge. As Mr. Zolo mentioned, the total site area is approximately 26 acres, and of that, environmentally sensitive slopes are located 1.5 acres. The town staff has indicated those areas in yellow. Just wanted to point them out with the sizes. So- Oh, okay, thanks, yeah, thanks. This area here in yellow to the northwest, I'm having trouble with it. There it is, okay. So this area here to the northwest is about 0.85 acres in size. The northeast steep slope area is 0.3 acres, and the third yellow to the west there is also about 0.3 acres. I note that the town requirement is 15% or greater. This northwest area has slopes up to about 20%. The other 2 areas were just over the 15% requirement. Also, there's a presently disturbed area in the center of the site, which was mined way back, which has steeper slopes, but those aren't natural. We had significant negotiations with the town. I think we made 6 different applications back and forth with revisions to come to the layout that you see here. We're proposing to cluster the lots between half-acre and quarter-acre lots in size. As Mr. Zolo mentioned, we're proposing a significant buffer along the west side, which is the result of the clustering. So what we have along the west side is a minimum separation between the property line and the westernmost lot of at least 80 feet. Most areas along the west that you can see are not being developed in this area here. Those buffer areas increase over to 150 feet or so. The buffering, the reason for the clustering and the buffering is to minimize the impact to the proposed slopes. You can see the northeastern area there in yellow is not going to be touched at all. Only the southern half of the northwestern steep slope area is going to be occupied with 2 lots, and the southwestern environmental area is going to be included with 1 lot. So the result of the clustering was to minimize the actual disturbance on any of those lots. And also I wanted to point out that we are achieving all of the grading shown with using retaining walls only for that 1 lot, number 10, which would be maintained by the homeowner and not involve the town at all. The other thing I wanted to point out is the Kings Park Road is an existing map street, which we are tending to reutilize, and we are constructing the loop road as part of this application. I understand that it'll be necessary to go through preliminary hearing with planning afterwards, but obviously we're here for the need for the slopes, and I'm happy to answer any questions that you might have regarding the site plan.
All right, thank you. Anyone on the board have any questions on this application?
Just to clarify, this property is the further west, if you can deem the parcel kind of like 2 pieces, one on the east side of the Kings Park Road, Paper Street, and one on the west side. The larger parcels on the west, smaller parcels on the east, and all of the development other than the recharge basin would be on the parcel to the west.
That's correct.
Okay. Thank you.
Anyone else? No. Planning?
No, thank you.
I'm going to get to it. Again, we're going to bring everybody up one at a time. Everybody gets 1 opportunity to speak. Once you're all done, I'm going to bring Mr. Zolo back to answer your concerns, and then the meeting will be closed. Okay? Who's first? Good evening.
Good evening. My name is Mike Rosato, 12 Country Oaks Drive, Kings Park.
You spell your last name, please?
Sure, R-O-S-A-T-O.
Thank you.
With the Kings Park Community Association. Just to be transparent, I own a parcel just to the east of this property, an acre parcel. It's obviously not involved in this proposal. But I used to come in front of this board from time to time when I was president of the Kings Park Civic Association to fight projects like this. I got involved in a project after I left the Kings Park Civic Association, and I was undermined by members of the planning department, the town board, the former supervisor, the current supervisor, the Kings Park Civic Association, the Kings Park Chamber of Commerce. So my perspective has changed, and I've always come in front of this board to do the right thing. What I thought was right for the community, for the environment, for the people of Kings Park, and I'm here again to do that. But I take a different point of view. When somebody who owns property comes in front of this board to do something positive with the property that they own. But they need to come here in order to get it through. I've always felt in the past, and I still feel today, that we need to follow these considerations. So I'm not here to stop this project, but I am here to try to alter the project. There's environmentally sensitive land here. There's absolutely no reason why this developer has to use that environmentally sensitive land for this project. There are steep slopes, and according to consideration number 4, whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district, it's quite apparent it does. There are rules. There are environmentally sensitive pieces of this property that should be avoided. Now, he can build this project with less homes, avoiding that environmentally sensitive land. And I'm here to ask you to consider that, to do the right thing, to uphold the rules that the town put in place to protect environmentally sensitive lands, like they show on this map. Thank you.
Thank you. Next. Good evening.
Hi. My name is Robert W. Steger, S-T-E-G-E-R,
Your address, please?
3 Old Road.
Okay, thank you.
I'm on the corner property right there on Old Road and Linden. And he has the, where he's going to bulldoze, I guess, to flatten it out, going right into my backyard. The yellow area you were saying, where number 9 is? Right there. That's my backyard. Now, how is that going to affect the flow of water and everything else, you know? What is he going to do? He's going to flatten that out? Maybe you can explain that a little more?
Okay, we'll ask him.
All right. It's just a shame that's all nice, beautiful woods.
Okay. Thank you, sir. Come on up, sir.
Good evening, ladies and gentlemen. I appreciate you having me come up. My name is Rocco Caporaso, C-A-P-O-R-A-S-O. My address is 18 Linden Avenue, Kings Park, New York. So I don't know what the gentleman is talking about, a buffer zone, but for the past few days, there have been trucks right across the street. There's all woods on Linden Avenue, right across from my house. And I looked there today, there's a bunch of stakes in the ground. So I don't know, what are we talking about, a buffer zone, if there's stakes in the ground staking out the property? So why would they stake out the property, okay, if the board didn't even give them the green light to start on the property or do anything? So I'm trying to understand what's this buffer zone, 5 feet, 3 feet from off of Linden Avenue, 200, 800, 900, how many feet? And then we're talking about half acre or quarter acre. I thought it should be half acre zoning. So if it's half acre zoning, I mean, that's fine. Listen, I don't have any problem with the progress. You know what I mean? I understand. Live and let live, you know? But, you know, we're talking about quarter acre zoning, and then we're talking about half acre. I mean, which is a lot nicer. You know, it gives a nicer appearance than, you know, houses right next to each other. Like, we're not living in Queens, or we're not living in Brooklyn. This is Long Island, you know what I mean? And this is the country. That's why all of us out there moved out here. I mean, because, you know, we have a nice piece of land, and we can wave to our neighbor. We don't have to say, yeah, here's a glass of water. You know what I mean? They're right next door. So I want to know, what's this buffer on Linden? And if it could be, you know, like I said, half acre instead of a quarter. I want some understanding of how many houses, what are we talking? 10 houses, 100 houses, 20 houses?
I think
What are
he-
we
I
talking?
think he said 36. 36.
Okay. All right, and I appreciate you addressing that as far as what this buffer is, when I saw trucks in there and
Sure.
everything is already staked out. Thank you, and I appreciate your time.
You're
Thank
quite
you so
welcome. Thank you. Who's next? Who's next? Anybody else? Good evening.
Good evening. Thank you for letting me speak. My name is Jim Rayo. I live at 2 Old Road, Kings Park, right across the street from the proposed development.
Jim, spell your last name.
Rayo, I'm sorry, R-A-O,
Okay,
like
thank
the
you.
sauce. You know, just to echo the last individual, you know, really concerned about the buffer. My house is directly across the street from this proposed development. As it is now, you know, I have a 13, 11, and an 8-year-old, and they've never been allowed to go in the street. Because unfortunately, coming off of Old Northport Road, people use that basically as like a speedway. And they hug that curb, they come flying around, and the first stop sign is actually past my house in front of the Steiger's house over here. So, you know, there's already so much speeding. I'm concerned about the traffic, what this is gonna entail as far as maybe another, maybe proposed stop sign really at the corner of Old Northport and Old Road, right when you enter the area, just to kind of slow that down a bit, because as it is now, it's terrible. And that's when people do decide to stop at that stop sign. The other question I had was, you know, so the buffering was really the last time, you know, I was at a hearing was in 2019. I guess that was, you know, the proposal to go from light construction to residential. At the time, the concern most of the people had here at that time was the drilling. And, you know, what was done in the past, the tests that were performed that got them to the point where they could potentially view it as safe to build there. I bring that up because I've been here since 2005. And back in about 2012, for those of us who've been here then, there was construction done, and there was an unbelievable odor that was emitted round the clock. And this is at the time, it might have been 2011, where trucks come in the middle of the night, and there was construction being done in that area. And, you know, a lot of shady things being done late at night, and there was just a lot of different types of materials dumped in that area, all throughout, the whole area. Obviously not the wooded area, the, you know, open area. So, you know, at that time, 3 years ago, the discussion was, okay, tests will be done to see if this could be deemed residential from light construction. But most people here at the time, the big concern was the safety of, you know, you're going to put houses on top of this area. I understand it's going to be going more or less in the area that's currently wooded, which kind of doesn't make sense because you have a whole open area right on the other side of that, which I don't know if that's, you know, owned by these individuals here, but to remove a lush area that's really part of the beauty of Kings Park, to put stacked homes as basically detailed. I mean, I grew up in Levittown, okay? I know exactly what the prior person spoke about. You know, our side yard, you could see what the other people watching on TV. We're out here for that reason, to kind of have a little bit more space. And, you know, to have land developed on quarter acre is really ridiculous in Suffolk County, anywhere, you know, let alone be a nice lush area that we already have. So you're basically just bringing a whole city type, you know, ideology. If we wanted that, we've moved back to Brooklyn and Queens, or deep into Nassau. This is not what Kings Park or Suffolk was, you know, really the ideology of. We still have the beauty of this, and to just compact all these homes in such a small area doesn't make sense. The concerns on the buffering, concern on the traffic. It's a very highly traveled, heavily sped area, and just to add more to that element, I know people who go to the school, my kids go to the middle school in Compton, I drive them. You know, there's no way I'll ever let them walk in that area as it is now. Now you're gonna add all this with, I assume, one entryway in from a, you know, entrance for 36 homes in a consolidated area. I mean, when you talk about quarter of an acre, what's the estimation on the number of people? You know, 36 homes, average of 3 people, 90, another 18, 180 people in a tight area, and then with 1 or 2 entries in and out. I mean, the danger that that's gonna pose to all of us, particularly those with kids, who I can't even take advantage of my street as it is because of what's already going on there, is just very frightening. So it's a quality of life issue, and then the fact that if this is gonna extend into an area where there are, you know, the trees, you know, where the trees are not, from years past, all the dumping that was done, whatever type of soil remediation they tested, that's a concern, because when they were doing dumping at the time, you literally could smell odor from the Superior Ice Hockey Rink all the way down towards the Akamsit School. And that was horrific. And we live, I'm right over by, I guess it's a bird sanctuary, and it goes up into Country Woods. And there were people in Country Woods that were here at that meeting, because even though they weren't within whatever the stipulation is to have the letter sent out to the neighboring X number of feet, the people affected in that area, they just got word of it and they smelled it. And they were sending letters and whatnot. So, that just didn't magically go away. What happened was they stopped drilling, they stopped dumping, they stopped doing whatever they did. But all that contamination still persists. And the way it went 3 years ago, I'll be honest with you, we didn't hear anything after that meeting. There was no further, any information provided as far as if it passed. So the fact that at the time it was going from light residential to light construction to residential, we never really knew the outcome of that. So now here we are now 3 years later, and yes, it's been really just desolate. There hasn't been anything done in the past 3 years in that area. They did, just before that hearing 3 years ago, knock down the shack. And I think someone said, yeah, the owner spent $4 million to knock it down. We could all knocked it down with everybody bring a shovel to it because it was falling as it was. But there's been nothing going on there in the area for years since that meeting. To the thought that something's been cleaned up and now you can put housing on an area that, you don't have to be a scientist to understand, it's contaminated. And now they're going to extend and put houses and jam them in there like sardines so you can just max out the profit of the dollar. There's a lot of concerns.
Great. Thank you. Anyone else would like to speak? Is there anyone else that would like to speak? No? All right. Mr. Zollo?
Thank you, Mr. Chairman. I'm going to have Mr. Marinas come up also just to address some of the issues regarding the buffer. But Mr. Rayo's concerned, we talked about the odors and stuff. There is a property that is to the east, which is referred to as the Jesualite property. That is a DEC site with dumping that went on there. So possibly that's what he's speaking about. But I also highlighted to this board when I talked about the rezoning that was granted by first recommended by the planning board and approved by the town board, there was a full environmental impact statement done, and issues concerning what was raised by Mr. Rayo were all addressed and considered during that environmental review process. And ultimately, the draft environmental impact statement was adopted by the town board as the final impact statement. And the recommendation from that was that the site was acceptable, and they recommended that the proper use of property consistent with the least impact would be a residential zoning for the property. So perhaps maybe there were odors, but I don't believe it was coming from this property. And the property's been dormant for a while because we started with a planning department application for site plan in 2020. And as you know, there were intervening actions and pandemics that slowed down this process a bit. So we're here today with a plan that is a clustered plan, which was recommended by the planning board, accepted and adopted by the town board, that the rezoning be granted and the development of the property be done in a clustered fashion. And one of the things that Mr. Marinas will discuss is that where we are trying, as we talk about the considerations, we're trying and come at this board with what we believe is the least amount of disturbance of disturbed sensitive slope areas that we can accommodate. There are other ways to do it, which means reduce the buffer that we have throughout the property, and then would disturb less property. But the town planning department worked with us and recommended certain buffers along Linden Avenue that would address their concerns. And ultimately, through discussions, we came up with what was believed to be the least variance required and the least amount of slopes that would have to be disturbed. Then, so I'll have Mr. Marinas just come up and talk to you about the slopes and what areas are being protected for buffer and how it would change if we didn't come here for this variance.
Okay.
Good evening. Just to clarify, the reason for the cluster and the negotiation, the meetings with the town planning staff was to achieve the layout that we have before you today. What we're proposing is a buffer of at least 80 feet to lot number 10. No proposed development is going to be closer than 80 feet. It actually increases to closer to 160 feet where we don't have any lots in between lots 10 and 11 to the north. So there was a concern about how close we're going to get to the neighbors. 80 feet is the closest. 160 is the distance to the north there.
Can I just clarify, 80 feet is to the property line?
I'm sorry, I misspoke, 70 feet.
Okay, and that's
I
to the
shouldn't have said
property line or
82.
to the structure?
It's from the property line to that retaining wall.
Okay, thank you.
I misspoke, the number's 70.
So a minimum of 70, a maximum of 100 and,
Well, a maximum, if you look at the southern portion of the site, it's goes all the way to the road. I don't know if it's possible to scan. Slide the picture, but if you look a little further to the south, we have a continuous buffer all the way, yes, right in that area there. It's all continuous. Right, that whole area there is to remain natural, so there is no development along the existing road either. The other thing I wanted to point out is that buffer area that you see along the southwest and north, not only does it encompass a lot of the existing steep slopes, but the size of that is 7.5 acres. The size of all the steep slope areas is 1.5 acres. So it's possible to reconfigure this design, leave the environmentally steep slopes untouched, but develop the same 36 lots and utilize those buffer areas, if you follow what I'm saying. Also, I wanted to point out that we're proposing the development is going to be about 30 feet below the neighboring lots to Linden. We're going to be significantly lower than those lots, so I don't visualize any kind of visual impact to the neighbors, plus the fact that we're going to be leaving at least an 80-foot treed buffer along the west side. I don't know if there was confusion or not with regard to traffic, but we're not proposing any access to Linden. All of our access is to the existing road, Northport Road. And again, I can answer any of the questions that you might
and
have.
there's 2 exits? and
No,
entrances?
just the one.
Just the one?
Just the one, that's correct. Yeah, Kings Park Road, it's an existing mapped street. It's not currently built, but it is mapped.
Oh, okay.
That's the only road we're going to be utilizing.
Excuse me.
The proposed road runs along the east side of the site.
Right, Kings Park Road is basically a paper street right
That's
now that
correct.
exists in between Linden and Old Lawrence, correct?
Yes, correct.
I had another question.
That's west of the Jeswali piece.
One of the neighbors, I believe it was Mr. Sturger, I'm sorry if I pronounced that incorrectly, was concerned about water runoff. Just to clarify, his site, the lots 8, 9, and 10, which are closest to that portion, are also lower in
Yes.
runoff.
Right, that's one of the reasons why I wanted to point out that we're significantly lower by about 30 feet. And we're also obviously proposing a recharge basin to collect all of the runoff from the development.
Thank you.
The basin itself is about 1.5 acres, but we have another 5 acres of buffer around the basin on the eastern lot.
And that eastern lot would be just left to,
Yeah, that's,
Natural.
yeah, there is some, I believe there's some old foundations in that area. We're not proposing to develop any of that. The intention would be that it would be left to grow natural.
thank you.
So there was a concern about development of our buildings on previously developed areas. That's not the case. The existing eastern lot was the one that had some development on it, and that's where the basin will be.
And Mr. Tansey, that's the lot that's east of the Kings Park Road, paper street.
And there is a possibility of avoiding going into the steep slopes, but you would have to reconfigure those homes into the area that's supposed to be open.
Right, we would lose the buffer, essentially.
How much of a buffer you think you'd lose?
Well, the numbers would be, we're preserving 1.5 acres of steep slope, and we're creating 7.5 acres of buffer. So we would have we would at least lose an acre and a half, but it would be more. I would say half if I had to estimate a number, probably about 3.
Okay, all right, thank you. No? No? No, said it 3 times. I'm sorry. Can I have a motion to close the application, please?
So moved.
Motion has been made to close the application, it's been seconded, all in favor?
Aye.
Motion carried.
Thank you very much. Good night.
Thank you.